You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at todaysfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.
Hello, welcome along to the latest Today's Family Lawyer podcast. Today I'm chatting with, I might describe you as a celebrity, June. June Venters. June is both a barrister and a solicitor. And we were just chatting before we started the discussion that sometimes that can leave people a little glazed over, June. But it's lovely to have you on the podcast. And today we're going to be talking about yourself, some of your experiences in the law, and also looking at how the role of the barrister and the lawyer might have changed a little bit during the period of time that you've been qualified. So thank you very much indeed for joining.
Thank you very much for having me.
I feel as though I've done your introduction an injustice because there's so much that we're going to talk about today about yourself. But perhaps in the first instance, you might tell us a little bit about yourself. Who is June Venters?
It's a question of where do I begin, really. At the end of the day, I started life in southeast London, born and brought up in Camberwell initially, and then moved to Peckham when I was 5 years of age. And I remained in southeast London all throughout my childhood, teens, and into my late 20s. So that's where I came from. That has a bit of a history because so did my father, and so did his mother before that. So all three of us were born in Camberwell, so we have a bit of a history there.
What was it about the law that appealed to you from those humble beginnings in Camberwell?
I think there are so many influences, to be honest, that caused me to go in the direction that I did. Some of them I think I absorbed without realising it, but it's only when I've sort of got much older and I've really reflected on why I went into the law that it sort of all came together for me, really. I suppose to begin with, as a child, I witnessed a lot of social deprivation because Peckham in particular was not a particularly affluent area. There was a lot of crime. I lived in a council flat opposite a vagrant's home by the side of a railway line. My bed would rock from side to side when the fast trains went by. So I knew what it was like to live in that area. But I also had, and I consider that to be a major advantage, I had parents who had a tremendous work ethos and also had a tremendous sense of justice and of the need for observe the rule of law. And I think without realising that at all, that influenced me from a very, very young child. Going through my school days, I look back sometimes and laugh to myself because I was very, very often form captain, which I thoroughly enjoyed and which my husband says is typical of me. I had to be the leader, had to be the one at the front. And I suppose if I look back, there's a truth in that. But I can remember one particular instance which has always stayed with me, even though I was so very, very young. And I think it really demonstrates the sense of injustice. My mother, although was not a wealthy woman, had chosen to go back to work when I was very, very young in order to, believe it or not, afford for me to go to a private school. Now, I should say that lasted for 18 months because I hated it even at that very young age and was instrumental in a conspiracy with my maternal grandmother to change the direction. And I then went to a state school, but that's another story.
Right.
But whilst I was there, I witnessed an incident with a teacher physically abusing a fellow pupil who himself was only about 6.5 years of age. He suffered from terrible nosebleeds, and knowing that, when he had done something terribly minor and insignificant, she chose to smack him repeatedly across his face, causing him to have a tremendous nosebleed, and he was taken to hospital. I can remember standing there absolutely aghast at what she was doing, and I honestly do believe that's one of the first things I recall as a child, which made me realise just how unjust that was. Going on then through my teens, I was witness to some serious crime in my area. My father was someone that always used to want to go to the rescue of other people, and on more than one occasion I had witnessed him going to the rescue of, for example, someone who was being attacked in the street and so on, and receiving injuries himself in doing that. And I think all of that had an influence on me as well. And then as I got slightly older, into my very early teens, I used to do what we now call work experience with my mother. She was working then as a secretary in a solicitor's office. It actually turned out to be the firm of solicitors that had represented the Kray brothers and many prolific criminals in those days.
Wow.
She actually specialised in family law, not criminal law, but nonetheless, that was what the practice did. And during my school holidays, I would often go there and assist and answer the phone or go and deliver briefs and so on and so forth. On one particular day, I can remember being asked to take somebody to the Old Bailey. I was about 14 years of age and I took him in a black cab. When I got home that night, my father asked what my day had been like, and I told him that I'd taken this really nice man to the Old Bailey. So he inquired what was his name, and of course I couldn't really remember it, and then it came to me, or at least I thought it did, and I said, I can't really remember, but I think it was a Mr. Gray. Well, of course, it was Charlie Kray.
Wow.
I can remember hearing my parents debating the appropriateness of my mother having allowed me to take this very seriously dangerous criminal on my own to the Old Bailey. And I always remember that with a degree of amusement, because I thought it was very exciting, and I actually thought he was a very nice man, but obviously I saw a different side. So I suppose all of those, add them all up together, take a great big spoon and stir it around, and I think you get the June Venters that decided that really the law was where I wanted to be.
What a fantastic story, and what a wonderful introduction to the law as well. I think it's fair to say, June, that you haven't necessarily gone down the beaten path. You've obviously forged your own way, and that started back in 1991 with the launch of your own firm. I guess it might be fair to say at the time, being a woman leading a firm was quite unusual.
It was, but David, I always say when I talk to young people joining the profession, and I don't say this because it sounds good, I say it because I genuinely mean this. If I can do it, so can you. I've never considered myself to be the brightest in the box. I didn't come from a background where entering a profession came naturally. I was the first person in my family to do that. But what I did have was a very strong work ethos, which, as I say, came from my parents, realizing that you don't get anything in life unless you work for it. And I think right from the very beginning, I committed myself to working very, very hard. And it was hard to qualify in the law. Becoming qualified, certainly when I was studying, the amount of work that we had to absorb, the amount of education we had to absorb was considerable. But because I hadn't had, I think, the expectation, although I had gone to a grammar school and I was very fortunate to do that, I hadn't got the expectation of entering a profession. And therefore, I really sort of had a contingency. And so what I did, I worked during the daytime as a secretary, having gone to secretarial college so that I at least had something to fall back on. And I studied in the evenings and at day release as a legal executive to begin with. And how I then became a solicitor was really seizing an opportunity that came along. And this is something else I also say. Opportunities in life are often presented to us. And I appreciate that not every opportunity materializes, but if you don't give it a go, you don't know.
Mm-hmm.
And an opportunity presented to me when I was working as a trainee legal executive attending day release, whereby unexpectedly I was told the department in that firm was going to close down. I was very upset, asked if I could go for a walk, think about things, and I ended up in the office of a friend of mine who was going to law school the following Monday. I was feeling very sorry for myself. Her boss asked me what was wrong. I told him, and he said, well, why don't you go to law school next Monday? And I laughed at him because I said, well, it takes 3 years. My friend's been on the waiting list for 3 years. I can't just go to law school like that. So he said, well, have you rung them? And I just said no. He then did so. So this man I'd never met before in my life picked up the phone and rang law school. And he was told in the first instance, you have to be joking. And then whilst he was on the phone, the woman asked him to hold on for a moment and came back and said, well, you'll never believe this. I've been handed a cancellation. If she wants to go to law school, she goes on Monday.
Well, I never.
And that's how I went to law school. So for all the career meetings and the thoughts of what career you wanted to go into, although I think I always wanted to go into the law for as long as I could remember, I never had the confidence to believe that I would actually make it as a solicitor or barrister. And for that reason, I never formally applied. But when this opportunity came along, I thought, what have I got to lose? And I took it. And I can honestly say that I walked through the doors of law school, and after that very first lecture, I knew I was where I should be.
I think there's so many times in life where we have these sliding doors moments, don't we? And it's quite incredible what opportunities present themselves. One of my favourite sayings, and it's a saying from my mum. So and we all know how right mums can be from time to time. The decisions we make at the time are, generally speaking, always the right decisions for us at that point in time. We can look back at them and say whether they were right or wrong, and people talk about hindsight being 20/20, don't they? But at that moment in time, generally speaking, the decisions that we make are the right decisions for us at that point in time, aren't they? And it certainly sounds as though it was the right decision for you. So moving on, we're qualified. You set up the firm in 1991. Tell us about that experience, because it's very different setting up a law firm today than perhaps it was back then.
It is. And something else I always say, that I'm not an individual, I'm part of a team. And whether that's a personal team or a professional team, I've always been part of a team. And when you say I set up my firm in 1991, I did, but I had the absolute backing and support of my husband. Now, my husband was a police officer at the time. He had an understanding of the law. He had an understanding of the work that I did, because, of course, I've always specialised in criminal and family law. And when I made the decision to set up the practice, it was effectively a joint decision between me and him. And in fact, he was the one that first suggested it to me, because, again, I think there was an element of disbelief in me that I'd actually be able to do that, because I'd worked with the same practice for 10 years where I'd qualified. I was very comfortable there. I was a partner there. And I didn't really think about setting up my own practice. It was only when he suggested it to me that I began to seriously think about it. And again, with his support and his backing, I was able to do that. So I really owe a lot to him for giving me the confidence to believe in myself in that respect. And that's how we set up. I was also very fortunate, and I should say this, the practice that I had been with, I was very, very fortunate that when I left them, I left on very good terms. And I was very fortunate because they passed all of my former clients on to me whenever they asked for me, which is quite a rarity, actually.
Yeah.
But that gave me a tremendous head start.
I've certainly heard, of firms where that practice does happen. We've certainly heard of cases where it doesn't happen as well, haven't we? But that put you in a really strong position to get the practice up and running.
It did.
Tell me then about the decision that led to how you became the first female solicitor to become a QC.
Well, again, it was the suggestion of somebody else and then the support and encouragement of my husband to make the application. I was sitting in my office one day and I had a call from my receptionist, and I can remember I had 2 members of staff in my room at the time. And the call came through and I was told that there was, and I won't name him, but there was a senior, as he was then, Court of Appeal judge on the phone wanting to speak to me. Now, I had appeared in front of him when he was in the High Court in a fairly complex children case, but I had no idea why he was calling me. And I should put it into perspective, because with solicitors, we have tended as a profession not to mix so much with judges as the bar have always done, because they've always had a much greater social professional connection with the judiciary. So for this Court of Appeal judge to ring me, I wondered what I'd done wrong. So I answered the phone, and he was, as he always was, extremely charming, and said to me, or in fact asked me if I was aware of the competition. And I didn't have a clue what he was talking about. So I sort of hesitated and asked him what he meant, what competition. And he said the Silks competition. It's been advertised in the Times. So I said yes. And he said, well, I would like you to apply. And I was taken aback, but I laughed and said, me, I'm a solicitor. There's no women solicitors that I know of that are Silks. And he said to me, well, whether there is or not, I would like you to apply, and I would like to support you to do that. So I said I'd like to think about it, and I went home and told my husband, and he said, well, what did I think I would do? And I said, well, I don't think I can apply. I don't stand a chance. And I always remember his reply to me, or first of all, he said to me, well, why? Why don't you want to apply? You say you're not going to stand a chance. Why not? And I said, well, if I don't get it, which I don't think I will, I'm going to feel really embarrassed. And his response to me was, well, are you going to be walking up and down Chancery Lane with a placard on your back saying, I've applied to become a Silk? He said, who is going to know? So applying the same philosophy that I did when I walked through the doors of law school, I have nothing to lose. That's what I did. And I applied and I went for my interview. And to my amazement, I was appointed. I've always believed I was the wild card because I was the first woman solicitor, but that's how I came to apply. So again, I have someone else to thank for pushing me on.
I'm absolutely certain, June, that you do yourself a disservice. You've talked about the way that people have cajoled you and influenced you, but it's you that ultimately is making the decision, and it's your ability that's putting you in these positions of opportunity. I wanted to move on and ask you about some of the most rewarding aspects of your career, the cases that you've had. And beyond that, you talked about the fact that if you can do it, anyone could do it. Again, you're doing yourself a disservice, but that confidence, or sharing that confidence with people that we don't have to look at glass ceilings and think we can't break through them.
Absolutely. I think, and I always say that the most important thing is to want to do it and then be prepared to work for it. And one of the sayings I always use is that if you fail to prepare, you prepare to fail. And I know that just as I know my failings, I know my strengths. And I know that one of my strengths is that if I have to work through the night to do something, I will do it. And I've done it as recently as within the last few months. That's always been something that I've been able to do. I thank goodness that I've had the health to do that. But you have to work hard.
What professionally have you found that's been most rewarding about the work that you've done?
I think there are so many cases over the years, and I was asked only very recently about what high profile cases have stuck out in my mind. And really my reply to that is, it isn't often the high profile cases that actually stick out in my mind. It's the cases where people haven't been able to achieve access and then all of a sudden have done so. And they're the sort of cases that stand out in my mind. But I mean, I can give you so many examples, but for example, a father coming to me in the last 2 to 3 years, having gone through the court service for something like 7 years already, where the mother of his children was preventing him from having contact with his children, and where there had been previous court hearings and so on and so forth. And then faced on this occasion with the most serious of allegations, which included sexual abuse, which he maintained was absolutely untrue. And as I got into the case, it was so obviously untrue. And going through that process with him, and eventually, after so much work and unearthing of facts that needed to be unearthed, and going through 2 very difficult, long, contested hearings, firstly to determine the facts and secondly to determine where the children should be, then achieving what ultimately was the only outcome that could have been achieved, which was the transfer of the children's care to him permanently.
Wow.
And being on the end of the phone to receive a phone call from the tipstaff at the High Court telling me how they had safely transferred the children into his care, and telling me how warm and loving the children had been towards their father, who up until then was being told repeatedly by both the mother and indeed the children that they didn't want to see him, when in fact that was clearly not right. And then every Christmas morning since, receiving a photograph of the family together is what makes what we do worthwhile. And there are so many other instances like that where families have been separated unfairly, unjustly, and having to go through an arduous process of effectively going through the evidence and demonstrating that whatever has been said as the reasons why they shouldn't see their children, in fact, were untrue, baseless, and so on. And knowing that the children who up until then had been deprived of relationships with their parents have been reunited, that is something worth fighting for.
That sense of injustice takes me back to the 6-year-old boy who was beaten around at school. That you obviously felt very strongly about at that moment in time. I want to pick up on something that you've talked about there, and there's a wry smile on my face because you described the family system and this particular case as an arduous process. And sadly, and I've done a very recent podcast about court delays. That's a whole other conversation, June. But is that your view? Is that your take on family justice? That this is still a very arduous process, regardless of whether you're a solicitor or a barrister or a judge or a client?
Absolutely. And obviously with the pandemic, it affected so many cases that there are now enormously long delays. There are so many ramifications that flow from that. And let me give you just a few examples. Firstly, what flows from that is that there is a tendency now for some cases to be limited by the courts in relation to what evidence they can produce, because there's a need to reduce the time that cases are taking, And the only way to reduce the time that cases are taking is to reduce the amount of evidence. And therefore that causes me, and I know many of my colleagues, some concern, because some cases are simply not having the evidence presented in the way that they should. Other cases, it is a battle to persuade a court to allow the factual matrix to be determined. And what I mean by that is to hold a fact-finding hearing. I've had cases which have horrified me, which I've inherited because they've transferred to me, which have already been going through the court process for 2 years, where judges have literally batted the cases backwards and forwards and backwards and forwards, trying to put pressure on the parties to settle, to agree that the children may see the other parent, when the allegations are so serious and sometimes they've involved rape. How can you agree that? You have to go through the factual matrix to decide whether rape was true or false before you can get parties to even contemplate coming up with a sort of agreement, if that's ever going to be achieved. You can't do it when there are serious allegations outstanding. And that worries me, because I think that there is a real tendency to try to cause parties to agree when that is not the appropriate way forward. Having said that, I move on then to another consequence, which can be a very beneficial consequence, but for the right case. And that, of course, is mediation. I am a mediator, a family mediator. I very much support mediation. And I always say, if parties can achieve agreement, that has to be better than a judge determining a case, because you're going to have one party that's happy with the outcome and one party that's not. Whereas with mediation, hopefully you may not achieve utopia, but you'll have two parties who've come to an agreement and can work together. So that is a consequence. And I think that many cases, not the type that I first referred to, but many cases are capable of mediating and should be mediated. And of course, the other consequence that flows from this, and which I think needs to be much more nationally promoted, is arbitration. So many members of the public are unfamiliar with the process of arbitration. And of course, arbitration is a tremendous substitute for many cases that would otherwise go through the courts. And I think it would be helpful for the public to be aware of what arbitration is about. And if I put it very simply, for most cases that I deal with, is exactly the same as the court process. The other advantage of that is that the process is much quicker, because there are not the long waiting lists, because you can select a date and time that's convenient to both sides. It has to be more expedient. And what follows from expediency is financial efficiency, because it's cheaper. In the long term, it's cheaper. So they are all of the consequences that flow from the long delays. But I do question whether the public has been made aware as much as they should be of the alternatives to going to court and the benefits of the alternatives.
So I think the follow-on kind of thought that I have around that, and it's a theme that I've explored in other podcasts as well, is whether the family law community needs just a better understanding of what opportunities mediation and arbitration offer, because I think there are times when we get very tunnel visioned as a profession into, well, this is how I've done it previously, and therefore that's how I'm going to do it again.
I think that's right. I think that there is a lack of cohesiveness in our profession generally. I think most of us are very often cautious about changes. I mean, going back through my career, I've seen so many different changes. And when we look at what those are, we've had the introduction of solicitor advocates, we've had the introduction of direct access, we've had the introduction of mediation, and we've had the introduction of arbitration. And I think all of those areas have created an element of skepticism by a large element of the profession. There's been concern that they threaten their own positions and their own roles, whereas in fact they can all complement one another. And going back to mediation and arbitration, mediation can complement legal advice, and arbitration, of course, is in many respects dependent on legal advice. So they shouldn't be viewed as effectively competing against family solicitors. They should be seen, in my view, as a complementary branch of the same wider profession. I mean, for example, just to explain what I mean, so far as mediation is concerned, when I mediate with clients, I will almost always suggest to them that they should seek legal advice before deciding on an agreement in mediation. But the advantages of going through the process first in mediation is that they obviously do reduce some of the work that they would otherwise be paying for a solicitor to do, but it doesn't eradicate the need for them actually seeking legal advice before they enter into an agreement and subsequently, because they're dependent on obtaining a court order if it's, for example, a financial matter in any event. So I would always recommend that they need solicitors to do that for them. So far as arbitration is concerned, although in theory members of the public could instruct an arbitrator to act as a judge on their behalf, it's very unusual and very rare as far as I'm aware. And ordinarily it would be solicitors who would be working with the client and the opponent and their solicitor to, first of all, identify an arbitrator and then prepare the case as they would, as if it was going to court. So again, it's a complementary service.
It's the proverbial no-brainer, isn't it? And you talked about cost expediency earlier in the discussion. Same concept, isn't it? It's the same principle. We're kind of leading rather neatly on to my final line of questioning. June, this feels a bit like 20 questions, so apologies. But I'd like to explore how your role has changed over the years that you've been practicing. But I just wanted to very quickly drill into 2 points that you've raised, one of which is the tension or potential tension between the people that are involved in the process, mediators, arbitrators potentially, and the lawyer. Is that something that you see there is a greater acceptance of in the family community?
Mediation, yes. I think when mediation really began to come to fruition, I was very much involved at the outset with a steering committee in relation to mediation and getting it out into the public domain back in 2009. I think that there was quite a lot of resentment then. I think there's a greater acceptance now of mediation. And there's also, of course, a big change in the rules now to how they used to be, going back to that time, because now judges will often put quite, I won't say pressure, but they will be quite persuasive about the need to consider mediation. So I think mediation has become much more acceptable than it was. I think arbitration is perhaps not necessarily so much in the public domain for it to become universally known about and accepted.
It comes back to the training point we've talked about, I think, doesn't it? And the awareness point.
I think so. And I think that it would be, I personally think it would be very helpful to have training for the profession so they have a greater understanding of arbitration. But again, I think we need to also be very clear that arbitrators don't just come from the bar, they also come from solicitors as well, just as judges come from the bar and from solicitors. And this leads me on to my collegiate approach, because One of the reasons I became both a practicing solicitor and barrister is because I admire both professions immensely. I think that we both have attributes, and I've always believed that there will eventually be a fusion. And I wanted to be at the forefront of that. I don't necessarily think I'm going to see a complete fusion in my lifetime, but I very much hope that I will be a part of going in that direction.
Let me put you on the spot now, June. Mandatory mediation, yes or no?
I think in some circumstances it could work, but it does go against the philosophy of mediation, which of course has always been that it is voluntary. But the downside of that, and this is the balancing act that I think has to come into the equation, the downside of anything that is voluntary is that it's not binding. So I do see some strength in mandatory mediation, but my caution is that we have to be very careful. And I go back to what I said earlier about how we as lawyers are finding that we are sometimes struggling to have cases that should be listed for fact-finding hearings listed, because the courts are desperate to reduce the list, thereby reducing the delay. And in doing that, they are trying to get couples to agree when it is so obviously not achievable. And that is something that I'm really concerned about, should not be brought in to the equation of mandatory mediation, because if you're going to have that, then we're going to have even more delay.
We're fast moving towards the end of the time that we've got for the discussion, June. It's been wonderful to have you on and chat through your experiences and some of your own thoughts on what's happening in the community at the moment. I have a little analogy that I wanted to share with you, which was shared with me a little while ago, and I found quite useful in the context of what you've said about the changing role of the family lawyer and the role of other people in the process. And it was a chap who had recently had surgery, and he was saying to me that it's not just the surgeon who does the job. Actually, there's a whole raft of people in and around the theatre that play such an important role: the nurse, the anaesthetist, the other people in the room, the doctors that end up doing the post-operative care. And that's how we have to start thinking much more about the role of the lawyer. Are we on the right lines with that kind of thinking?
Absolutely. And it's something that I've always believed. I think I said at the very beginning, I've never considered myself an individual. I'm not an island. I've always considered myself as part of a team. Whenever I am instructed through my firm, what I always do is select a team to work with me. And there will always be a minimum of 3 of us. I don't believe, firstly, from a client's point of view, that they necessarily always need me. I'm the most expensive, and I therefore try to delegate what work I consider to be appropriate to the appropriate level of people. But I also believe that as a profession, we all need to recognise the qualities that we can all bring to a case. I was president of the London Criminal Court Solicitors Association many, many years ago. I have tremendous respect for criminal solicitors and duty solicitors. They work enormously hard and they're highly competent. However, for a number of decades now, they have been seriously underpaid. And it was because of that I chose not to continue to do criminal legal aid, and I gave it up in 2009. And the reason I did that was I was never going to be able to offer that type of service that I just described to you on legal aid rates without going bankrupt. And I also wasn't going to be able to pay my staff what they were worth. So I came out of legal aid. And that to me is one of the saddest reasons for leaving what I consider to be an element of social access to justice. But working as a team is essential and giving the quality of service that emanates from working from a team is important. And that's the way I've been fortunate enough to continue to work. But it saddens me that I don't think that's able to be worked in that way through legal aid anymore, in the criminal justice system at least.
Topic of a whole different podcast, I'm absolutely sure, June. But thank you so much for sharing your insight today. We've kind of reached the end of the discussion, and it's been fantastic to have you on the podcast. Thank you so much for joining.
Thank you for inviting me.
The Today's Family Lawyer podcast is available on your preferred podcast provider. It's also available on todaysfamilylawyer.co.uk. My thanks to June. Thank you for listening, and we'll see you again soon.
You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at todaysfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.